Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. This is our Tuesday night live show. We're going to go for about an hour, and then we'll go to our Patreon show shortly after that. But let's see what we are going to talk about this evening. First, we got the Bryan Kohberger matter. Doesn't it just, part of me says, why do they do this stuff to make issues? Why does the prosecutor help make issues? Like, just turn this stuff over anyway. We'll get to that. And then I think it's worth noting, and we're not going to get political in any way, but we're going to look at the target letter that former President Trump received. Let's face it, people can jump up and down and say it's political. And frankly, let's face it, it's political. All right. But the reality of it is that when your client is indicted, whether you think it is a political hack job or not, you have to defend it. Your client's liberty is at stake. So I think that's worth talking about today. And I have always said it, and I will say it again. It's always the defendant's own words that get them. Well, and frankly, that may be the situation with the former president as well. Anything you say can and will be used against you. People don't really seem to ever get that, but that's just the way it is. All right. For those of you who have watched us before, thank you for joining us again. We know that you are busy and you have lots of other things you could do. So the fact that you came to be with us, we appreciate that. For those of you who this is maybe your first time joining us, or maybe it's been a while, like I said, my name is Scott Reich. I am a practicing criminal defense attorney. Been doing that for 28 years. So the reality of it is that I've handled just about every type of case out there, not only in state court, but federal court. And except for, maybe an insurrection, rebellion, haven't had one of those. I've had potential clients come and ask me, hey, I've been charged with stuff in Washington, D.C., but the reality of it is they don't have the resources in which to pay for somebody to go represent them in a completely different state. That gets really, really expensive. So, like I said, handle just about every type of case out there. Homicides, heck, I've got, I think, 4 homicides on my docket right now. So, like I said, I have a pretty good idea of what the prosecution's going to do, what the defense should be doing, and what to expect. Obviously, there's a lot of stuff going on. We got, we got serial killers on each side of the country. That Heuermann guy for the Giglo, I think, beach murders. He's got 3, maybe 4, maybe more coming down. We've got this guy in Oregon that we talked about today on today's show, where he has even more cases coming down. He got his parole revoked because he got his clemency revoked when they figured out, oh, he's our prime suspect. Oops. I guess they didn't make the right call on that one. So just so everybody knows, I think it's funny to read the comments. I saw a comment today, Scott, it looks like you're becoming sounding more and more like a prosecutor than you are a defense attorney. No, just telling them the way it is. And like I said, I have none of these cases that we talk about are not my clients. Frankly, I couldn't talk about my clients' active cases, but I'm going to tell you the good, the bad, and the ugly. Like, here's the problem that the prosecution has. Here's the issue the defense has. And this is what you need to look out for. This is what's going to happen based upon my experience. I think we usually get it right, or don't come pretty darn close to calling it correctly. But, to say I'm taking a particular side, yeah, I think I'm pretty straightforward when I tell you, something really bugs me. Like, there are certain things that really bug me in the practice of law. Like, I don't know, for the example, let's talk about the Bryan Kohberger case. What really bugs me is when the prosecutors indict somebody and they know they have to turn over all this information. For example, like a grand jury, they have to turn over the grand jury transcripts. They have to turn over the grand jury exhibits. Everybody knows that. And when did Bryan Kohberger get indicted? Like back in May or something? And they still haven't turned this stuff over, which is causing delay, which is creating appellate issues. And it just drives me bonkers. Okay, we saw the same thing in the Lori Vallow matter. Remember? Lori and Chad get indicted at the same time. Chad appears, gets arraigned, sets his case out, waives speedy trial. So then, it really doesn't matter because you have the right to be tried within that first 6 months there in Idaho. And then they just keep setting it out. As far as Chad Daybell is concerned, his case could be tried in 2053 for all he cares. Okay. It's not getting any better for that guy unless all the witnesses die, disappear, get hit by a big bus. That's the only way his case is going to possibly get better. But you remember, Lori Vallow, she never made it to that first advisement and arraignment because she went off to the state hospital because people said she's not competent. Everybody agreed she's not competent. Let's get her down there. Let's fix her up. So when she came back, she wouldn't waive speedy trial, but the judge joined Lori Vallow with Chad Daybell. And then Chad got severed off because he needed a continuance because his attorney, Mark Pryor, wasn't ready to go try the case. Well, since they're severed out now, the judge didn't get her to trial within 6 months, set it out with a little farther. Like I said, I wasn't really impressed with Lori Vallow's attorneys. I thought it would have been a little more aggressive, but hey, that's their style. If they make the record, that is what it is. That's the bottom line. That's the bottom line. But it creates issues. If the judge just severed those cases out earlier, there would never have been an issue. But now she got convicted. She goes back for sentencing, I think, late August or something like that. And then they'll do the appeal. And, the court's basically already denied it. But of course, the trial court's going to deny it. Trial courts never admit that they're wrong. That's why we have appellate courts. Now, do I think the appellate courts are going to say, oh, my God, Lori Vallow is an innocent woman here? It doesn't matter if she's innocent. The question is whether she's going to get a fair trial. Did she get a fair trial? Did she get jammed up on the whole speedy trial thing? To be determined. I think it's one of the better issues they have on appeal because, frankly, the defense was pretty lackluster in that case. But the evidence was pretty overwhelming. Let's be realistic there. So then we got old Bryan Kohberger. He appears. He shows up. The court enters a plea of not guilty on his behalf. Everyone keeps making a big deal. More and more, I read more and more stuff about the Bryan Kohberger case. They make a big deal. He didn't enter a plea. The court entered a plea for him. Who cares? That's what happens all the time. You could stand silent. The judge says, fine, I'm going to enter a plea of not guilty for you. That's it. No big deal. Everybody keeps making a big deal about it. But that's half the problem with most of these shows out there, even on the, I don't know, what do they call it, mainstream media as well. Most of the people have no idea what they're talking about because, well, they've never tried a criminal case in their life. And so they keep looking for stuff to make a big deal out of it. All right, back to Kohberger. All right, he shows up. He gets arraigned. The defense files a motion saying, hey, judge, we want to challenge how the grand jury was assembled. Now, remember, in federal court, you have a right to be indicted via a grand jury. Okay, a grand jury is 15 or more people, usually 15 to 22 people, 25, of a bunch of citizens who sit around, hear, information about the case. Remember, it's just the prosecutor in there. He calls a witness. Usually most indictments on routine cases, it takes 5-10 minutes at most. It's very quick. And you've heard the saying, you can indict a ham sandwich. If the prosecutor wants somebody indicted, they get indicted. If the prosecutor doesn't want somebody indicted, they don't get somebody indicted. As opposed to the petite jury, which is a jury of 12 people, right? Petite, small, versus grand, bigger, all made up of citizens who are supposed to be fair and impartial and, withhold judgment until they hear all the evidence in the case. Well, like I said, the grand jury, you don't get to hear all the evidence in the case. No one's cross-examined. It's basically like the prosecutor, instead of writing an affidavit for an arrest warrant, they simply have the detective say what he would put on paper, and bam, somebody is indicted. So Kohberger shows up for court. They got the indictment. First, he was indicted on complaint, or he got charged with complaint information. A couple weeks later, the prosecution comes back with a indictment. Makes sense. They're going after, murder charges and the death penalty. Let's dot our I's and cross all the T's. Kohberger shows up, doesn't say anything. Court enters a plea of not guilty. Bam, that 6-month speedy trial clock starts to tick. That means the prosecution has 6 months from that date to get Mr. Kohberger to trial. If the prosecution fails to get him to trial, and what I mean is seat a jury, so as jeopardy attaches, the case would be dismissed if they didn't do that within 6 months. If it was 6 months and a day, doesn't count. Doesn't count when you bring in the jury. It's seating the jury. That's when jeopardy can attach. And no big deal. Trial is set for October 2nd. All good to go. But the defense says, hey, judge, we want to challenge the makeup of this grand jury. We think something nefarious was going on, but we just don't know yet. But we need to file this motion within a particular time. So we're asking you to stay or toll speedy trial, which means pause it. Like, you got your little clock on your cell phone. You start the timer, right? And when you go to the little stopwatch, I don't know if you can see that, you hit the start button. It's ticking away. It's ticking away. It's ticking away. And then you want to toll speedy trial. That means you stop it until a particular point. So the statute that the public defenders file said, hey, judge, we want to challenge this. And then it says that there's a stay that's put in place that stops speedy trial from ticking. Well, the judge said, hey, defenders of Mr. Kohberger, I get what you're trying to do, but it's premature because you haven't submitted anything. And I understand you can't submit anything because the prosecution hasn't prepared all these transcripts and giving you the exhibit lists, witness or exhibits that were used for the grand jury so that you can challenge it. And then you want to have all of the information as how they assembled, where did the grand jury come from, all the things you could potentially challenge a grand jury. Rarely works. I cannot think of one grand jury that was ever thrown out because it was, not assembled properly. You have to remember, usually the grand jury is, although the judge isn't there, it's supervised by the court. So there's a little bit of incentive for them to try to get it right. Doesn't mean they can't screw it up, but, hopefully reduces that. And so the judge in the Kohberger matter then says, but here's what I'm going to do. I'm going to deny your motion because you haven't given anything to do this. But I'm going to, under a different statute, I'm going to stay speedy trial for 37 days. Not exactly sure where the judge came up with 37 days, but he figures, 37 days is good enough for me. So they have 6 months from the date plus 37 days. And the defense also stated on the record, hey, judge, we understand your ruling. And yes, we understand there's an additional 37 days on top of that 6 months. So 6 months, 37 days. We will not challenge, violation of speedy trial if it's within 6 months, 37 days. 6 months, 38 days, we can challenge it, but not 6 months, 37. So the prosecutor comes in and files a motion saying, judge, you can't do this. You can't do this. We have an October 2nd trial date, which the judge said he's going to keep that trial date. But you had no authority in which to grant a 37-day tolling of speedy trial. You don't have that authority. So if Kohberger wants those 37 days, he needs to waive speedy trial because we just don't know. Is there going to be a trial on October 2nd? Is there going to be a trial, on November 10th? They want to know. The prosecution wants to know. And the prosecution cited a case in their brief that said, hey, judge, the Idaho Supreme Court has said that you can't really do a tolling and get the benefit of speedy trial. You can't have your cake and eat it too. So Kohberger needs to come in and waive speedy trial if that's what he intends to do. And if he's not going to do that, then, 37 days doesn't count. And why do we get into this little minutia as it relates to the Bryan Kohberger case? Why don't we talk about the DNA, right? Well, I think it's frankly interesting. And guess what? The case is not going to get reversed, assuming Bryan Kohberger is convicted. Obviously, we give him the presumption of innocence like we do everybody accused of a crime, unless and until they plead guilty or are convicted by a jury of their peers. So Mr. Kohberger is entitled to that presumption of innocence. We will give that to him. But why do we talk about that? Because these type of issues are what appellate courts and appellate attorneys are going to be looking for, because it has to do with legal errors. You have to remember, when somebody loses at the trial level, they have a right to an appeal. They don't get to appeal and say, Judge, I just didn't like the decision. It's obviously unfair. It's so obvious that I didn't do it. So find me not guilty. Give me a new trial. That's not what the appellate courts do. The appellate courts make calls or judgments on legal error. It's a legal error if the issue is raised, judge rules on it, there's an objection at some point. Remember, you have to object. If you don't object, there's no appellate issue. And that's why I was always surprised in the Lori Vallow cases. Like, why is he not objecting? Why are her defense attorneys not objecting more and more? You don't waive that. It's waived. If you don't object, it's completely waived. So it is what it is. So the appellate court gets it. All they have is that dry record from the transcripts. They don't get the emotion of the courtroom or the family sitting in the gallery crying, the emotion of it when they put up the autopsy photos, the judge wondering, oh, look at those potential voters out there. I'd really like to be retained. I just bought that new, winter house or summer house. I'd really like to keep my job so I can keep that going. Oh, I need to rule one way, but I want to make everybody happy, do my job, protect the defendant's right under the Constitution, but I want to get reelected as well. Oh, and the prosecutor's office is so powerful. Oh my goodness. And so the judges usually rule against the defense, which is fine. I mean, I think I'm not used to that after 28 years. Of course I am, because I have to tell clients all the time, listen, I have won trials where the judge ruled against every motion I've made. I have won trials where the judge has basically overruled every objection I've made, and we've won. I had one lately that it was bittersweet. In fact, I had a streak where I literally had like 3 trials back to back, and I lost them, and 2 got reversed on appeal. Apparently Scott maybe knows little something more than maybe the judge did on that one. Yeah. One, they kept allowing in expert testimony. I'm like, Judge, this is expert testimony. It hasn't been endorsed, and it's improper. Objected. Judge is like, I'll give you standing objection. No, Your Honor, I have found and learned that if I don't object, it's waived. I want to object to every question. Judge didn't like that, but guess what? Case got reversed. He got a new trial. Of course, I was going to be 10 miles away from that case ever again. Not going to do it. Other one was a jury instruction on a homicide case. I thought it was clearly self-defense. The judge wouldn't give us what they refer to as a non-lethal deadly force instruction, which is basically like, the guy died, according to the coroner. It was like a 1 in a million shot. Guy got poked in an arm, and the coroner's like, yeah, probably 1 in a million chance, probably take, similar situation, another 1 in a million chance that somebody would die from that. Judge didn't give the right instruction. Guess what? It comes back on appeal. So that's always interesting. So that's what the appellate courts look at. They didn't say, oh my God, Scott's clients were so innocent, it's obvious that they were railroaded. No, they weren't saying that, were they? No. That's what the appellate courts hang their hat on, and people need to remember that. That's how these cases get reversed. I mean, think about the Bill Cosby case, right? Was it because they said, oh my God, this is an innocent man? No, appellate courts don't care about innocence. They only care, was there some sort of legal error that resulted in an unfair trial? And when you had the Bill Cosby case, they brought in all that 404B evidence. And who kept saying that allowing all that 404B evidence in is wrong? I'm telling you, 404B evidence from a prosecutor means one thing. They have a weak case. And, I hate to say it, but who called the Bill Cosby case? Me. Said he's totally going to get convicted and he's going to win on appeal. Who also said, I think Lori Vallow's totally going to get convicted, but who has some good appellate issues on appeal? Lori Vallow. Not because I like Lori Vallow, not because I'm rooting for Lori Vallow. Frankly, I could give two, what's about Lori Vallow. But the point is that those are the appellate issues that people get wrapped around the axle. Everybody wants to talk about the sensational stuff that you're going to see on the front of the newspapers. Oh my gosh, the DNA evidence. Did you know that Bryan Kohberger asked girls out? He made them feel uncomfortable when he was staring at them. It's obvious that he's a killer. Well, that's not coming in. I can hardly think of any circumstances that would come in unless he got up and testified and said, I've never, Bryan Kohberger gets up and says, I've never done anything weird and creepy in my life. Then maybe that would open the door for the prosecution to rebut that. But probably not. Probably not. So if you want to get totally legal, geek, crime talk aficionado type stuff, it's the legal issue, not the, I got this fact and this fact. That's what juries decide. Do I believe this fact or this fact? That's it. Once the jury decision's made, that's done. Appeals deal with the legal decisions the judge made. And did it result in sufficient error that resulted in an unfair trial? It always cracks me up. You go to talk to a client and say, hey, man, you're looking at spending the rest of your life in prison. No big deal. I mean, it's you, but it's, I'm not telling you how to live your life, but do you want life at the, little sunlight at the end of the tunnel, or you just want to see if it's a big train heading your way from the other end? Is that what the shiny light is? They're like, man, I'm just going to hang my hat on my appeals. And I said, well, I appreciate your trust and confidence in me that I'm going to do a great job. But really what you're saying is, you're going to lose. I'm telling you, you're probably going to lose, or at least go down on something, and you're going to get more time than what the offer is. So I know the offer sucks and we can try to make it better. But, here's the reality. Only 2% of all cases that go up on appeal get reversed. And everybody thinks if they win on appeal that like they go home or something. No, it just means you get a new trial 3 to 5 years later. Now, I can think of one situation where did a trial. It was an aggravated robbery trial. Very similar cases in one jurisdiction and two jurisdictions. You have ag robbery up here, ag robbery down here, and the co-defendants all go to trial together. It was great. Got to great attorneys doing the case. I think two of them. I think they may be judged. I know one for sure is a judge. Anyway, she's very, very good attorney. Anyway, make a long story short, the main victim dies through no fault of any of the defendants. She dies. Natural causes. Like, boom, dead. The one jurisdiction says, wow, well, we can't use those statements because she's dead. That's hearsay. And they were what they refer to as testimonial, which means they have to be subject to cross-examination. And they weren't. So the one jurisdiction dismisses. Well, of course, I've got the case in the jurisdiction where the judge is like, I don't need to follow the case law. I know when a client is guilty, the defendants are guilty. I'm not going to let the law get in the way of the prosecution's attempt to convict these people because we all know they're guilty. And but for the fact that this woman had died, they would be convicted. Okay, judge, but you understand there's some pretty good case law on this, and you're completely ignoring this. I'm going to find under the residual hearsay rule that this is reliable hearsay from a dead person, and therefore it should come in. Even though we have no way to cross-examine the person, I just think that's unfair. But don't get me wrong, up until early 2000s, until the Crawford v. Washington decision came about, courts allowed in that garbage all the time. And in Crawford v. Washington, they specifically criticized the Colorado courts for their analysis on reliability of hearsay statements. Like, no, the person doesn't come into court to testify to it, it doesn't come in. How's that? Simple rule. Judge allows it all in. Yeah, so. Okay, we don't really know they said that because, they're not here and can't do it. Needless to say, all three co-defendants are promptly convicted by a jury of their peers, and it goes up on appeal, and it gets reversed. And the Court of Appeals is like, Judge, where have you been the last, 15 years? There's this case called Crawford v. Washington, where you can't allow in hearsay statements unless they're going to be subject to cross-examination. Case reversed. And the prosecution didn't go forward with a retrial in that particular case because they knew they had no evidence. Now, an ethical prosecutor in that particular case would never have gone forward in the first place. But he knew that the judge was I don't want to use the word hack. I want to use, let's say they were very prosecution oriented, because I'm not using the word hack. Okay. I don't use the word prosecution hack to define judges. All right. Let's just be clear about that. I said that they were prosecution oriented and that the judge did legal gymnastics to get to the result that they wanted, not to follow the law, which is one of my other pet peeves. You want to talk about pet peeves? How about a judge that wants to get the result they want instead of following the law? We can talk about that in a second. So, like I said, an ethical prosecutor never would have prosecuted that case because the one in the other jurisdiction I was talking about, that was the prosecutor's like, I can't prove this. That this would be unethical. I'm not even going to try to do this. But this prosecutor did. The judge went along with it. And while that case went up on appeal, 3 people had to sit in custody for a crime that they, under the law, should not have been convicted of. And yes, there was error that resulted in an unfair trial. Purple Haze said, you said hack. No, I did not say hack. I do not use that word to define judges. Let's just say, because I would never say, oh, the judge is some prosecutorial hack. No, I wouldn't do that. I would say that they are prosecutorial oriented, and that they, if they'd like to be a prosecutor again, they should come over and have a seat next to the prosecutor. Let's not engage in this legal fiction that somehow they're going to be fair on the bench, right? I use this example in voir dire when I try to find potential jurors. The goal is to find jurors that can be fair and impartial, reserve judgment till they hear all the evidence in the case, and then make their decision based upon the legal, the law in the case that the judge gives them. And I said, think about it, ladies and gentlemen, this isn't about, any political, it's just trying to find 12 good people. As a professor said in law school, 12 people good and true, otherwise unemployable. Not so much the case anymore. Lots of people in jury duty, they sacrifice. I have complete faith in the jury system, as long as jurors are truthful and honest. And so you ask them, hey, listen, you understand why we want to, if there's something you need to tell us, why you couldn't be fair and impartial, now is the time. But think about it. The reason why you ask these questions is because, say you're going to a Colorado Rockies baseball game and they just played the Yankees. The Yankees are in town. and you go out to the field. Oh, this is going to be great. The Rockies have a shot. They're going to be great. Yeah, sure. They have the worst record in baseball, but maybe this is their day. This is their day. And you go out there, and all of a sudden, the players are out there warming up, and then here come all the umpires. And the umpires are wearing New York Yankee hats. If you're a Rockies fan, you'd say, hey, that's not cool. I thought umpires were just supposed to call balls and strikes, not be a fan of somebody. I mean, you could be a fan of baseball, but not you can't pledge any allegiance to one particular side, because then it looks skewed and perception is reality and it's not fair. And everyone's going to leave the courtroom thinking, but the umpires were wearing, Yankees hats. It's not fair. And so you always, have to try to find jurors that get that concept. And most of them do. And most of them will say, you know what? Hey, if I was that defendant seated over there, I'm not sure I'd want me sitting in judgment of him. Maybe not that I wouldn't be a good person or a good juror, but maybe this case just is not the right case for you. And then, of course, you see hands start popping up like popcorn. Come to think of it, he does look guilty. Boom, boom. Hey, that's fine. Get him out of there. Get him out of there. So anyway, we digress. See, we talked all that time about the Bryan Kohberger matter. All right. Try to take a couple of questions here, and then we'll switch topics here a little bit. Facey Cad, Kohberger is the real victim in this case. The killer is out there. Casey, give me your theory. Why is it that you think Kohberger is the victim in this particular case? I mean, granted, we have not seen all of the discovery in the case, but once again, I have to be able to, as an attorney, say, okay, it's a complete railroad job, but it doesn't matter what I think. It doesn't matter what I believe. It only matters what I can prove. So, Casey or Facey Cad, just what evidence do you have that Bryan Kohberger has been wrongfully accused of these crimes? Now, I understand they have his DNA on the sheath. And since your CrimeTalk host, lovable, harmless little fuzzball CrimeTalk host, used to be in the Marine Corps a long time ago, still has his K-bar and has the sheath. Okay, for all the YouTube censors, we're not taking it out of the sheath, so you don't have to demonetize us or trigger somebody. Oh my God, he held up a knife. He held up a K-bar. Oh my God, it triggered me. Oh my God, I can't talk about it. It's a true crime channel, but how dare we talk about, real evidence and take a look at those things. So let's take about, we got the sheath. Bryan Kohberger's DNA. Boom, right there on that little button at the top of the sheath where the knife goes. So it makes you gotta wonder, kind of, doesn't it? Say, hey, I'm not the sharpest guy in the shed, but for a guy who doesn't go to that school, who no real evidence that he's been invited to other parties, no evidence that he was romantically involved with anyone at the house there in old Moscow, Idaho. How did his DNA get there? Now, I am open to listening to all plausible theories, ones that you can prove. Okay? Ones that you can prove. So you actually have evidence to say, sure, maybe Bryan Kohberger did, in fact, touch that sheath, but somebody else actually carried it. He's just a guy. The real killer maybe was at his apartment earlier in the day. Well, I would think if Bryan Kohberger knew who the real killer was, he'd probably tell them so that he could get out of custody and not face having his liberty or life taken. Just saying. Trish says, was the DNA just on the button snap or all over it? Now, my understanding from what I've read, it's all just on the button snap of the sheath. Like I said, now DNA was on there, somebody presses it, but one would have to say, well, geez, I mean, they have no receipt for Bryan Kohberger purchasing the K-bar. So how did it get there? I guess I could use I'm just a guy defense. Had a guy once who was charged with possession of a weapon by a previous offender. And he wanted to go to trial because, frankly, he had lots of other issues that they couldn't prove in the same trial. So it was like, oh, let's go. Let's tee it up. He was one of those fighters. I've been his attorney on a couple of cases, and it's always turned out well. Anyway, we tee it up. And it's like, oh, man, like your DNA's all over the gun. And we went with well, yeah, I touched it because I'm a guy. But it wasn't my gun. I didn't possess it. Yeah, I know it was a stretch. It was a legal argument, but we did what we had to do. Maybe that could be it. The real killer had gone over to the apartment, whereby showing Bryan Kohberger the K-bar in the sheath, he took it out. Upon returning the knife to the sheath, snapped it and gave it to the real killer, right? I don't know. A little unlikely. So if you think there's a reason, and don't get me wrong, we'll give Bryan Kohberger the presumption of innocence. I get it. But let's face it, anytime you have DNA, I'm telling you, when I first started practicing DNA, we were still doing Shrek hearings. We were still trying to determine if it was reliable. And my gosh, that would have been in 96, 97 that we were doing those issues. And now it's not even an issue. That was it. DNA is coming in. They have to lay the foundation, how they got it, how they tested it, etc. But for the most part, DNA is coming in. And most citizens are quite aware of DNA and ooh, it's there. You need to be able to explain how it got there. All right, we've got a super chat question from Juniper's Tarot and Magic. His contact DNA, he has his big face on video getting out of the car and walking into the store, circling the house 4 times like a creeper. BK is toast. I listen. I am a criminal defense attorney. I was a prosecutor for a brief period of time in the Marine Corps. I get it. And some people, oh, you're just a hack, Scott. You're just a hack. You are a defense attorney. You're always going to root for the defendant. No, because I have to look at things objectively. People always say, oh, attorneys just ignore the facts. The attorneys are the most attuned to the facts at hand because you have to try to deal with them and be able to explain them. And if you can't, you have an obligation to go to your client and say, listen, we can go to trial. I don't care if you confess. I don't care if you're on video. You have a right to make the prosecution prove their case. Maybe they can't get some evidence in. Who knows what will happen? But I need to tell you, I think you're probably going to lose because we can't explain it away. And, and the explanation that you've given to me, your defense attorney, I'm not sure that I can say that with a straight face in front of a jury. I mean, probably could say it, but then I'm probably going to smile because they're all going to be laughing, right? They're going to be laughing saying, are you serious? And guess what? I may look like a fool up there, but you are going to prison for the rest of your life. So the defense attorneys are always the most aware of the good facts and the bad facts, and they have to deal with them. And no case is perfect. If it was completely overwhelming, there'd probably be a guilty plea, assuming there's a reasonable offer. If it's a crappy case for the prosecution, it's not going to go to trial normally. So the defense attorney. So yeah, Bryan Kohberger has some problems. And yes, the defense never has to explain away anything. The burden always remains with the prosecution. But let's face it, the reality of it is you have to have a good explanation as to how the DNA got there. I always tell clients, if there's let's say an assault of some type, and let's just say there's various bodily fluids in various orifices of other individuals, and they've made statements that said, oh, I don't know who this person is. I have no idea. Looks a little disingenuous when you come back and say it was consensual. Now, if you said it was consensual from that moment, okay, that completely explains why the DNA is in there. Right? Yeah, of course I'd expect to see it. Of course you'd find it, right? If they said, well, we found DNA in your house. Well, I would expect you to find DNA in my house. Or you found DNA at your girlfriend's house. I would expect you to be there. I spent all kinds of time there. It was completely consensual. I came into her house. Just something to think about. I have faith in the jury, just like Scott. Tell us to have faith. Trust the jury, ladies and gentlemen. Juries are smart people. Okay? As long as you go in there with an open mind and that your solemn oath and obligation is to follow the law with the facts. And it is your solemn oath and obligation to say guilty if you believe the prosecution has proven their case beyond a reasonable doubt, which is not a vague, imaginary, or speculative doubt, but a reasonable doubt that would cause people to pause in matters of great importance to themselves. Okay? That's your oath and obligation. And if the prosecution has failed to prove any one of the necessary elements of the offense charged, it is also a juror's solemn oath and obligation to say not guilty, to make a decision with neither passion nor prejudice in any way to any side, to the prosecution, to the defense, to the defendant, in any way whatsoever. Okay? You have to do that. So I have faith in the jury system. Most of the time, the jury gets it right. Every now and then you scratch your head and say, oh, wow, didn't see that coming. Were you guys the same trial I was at? Because I totally would have found him guilty. Just kidding. All right. So you just never know. You just never know. Juries are smart people. They take the job seriously because for the most part, ladies and gentlemen, that's the most important job most jurors will ever have to do in their life, to make a huge decision like that will affect somebody's liberty based upon, limited amount of time, the best evidence the prosecution can come up with, and following the law. That's the best you can do. All right. Gonzi? Oh, no, that wasn't it. Gonzi. Love how you break things down. Well, thank you. That was the whole point of our channel when we started this little adventure. Gosh, 4 or 5 years ago now. Can you believe it's been 5 years? If I had a little more time to devote to it, I think we'd be at 1 million subscribers. And I need to really focus on that. We need to get to the 1 million. We just need to get to 1 million, Frank. How difficult can that be? At this pace, almost at 250, almost 250 after 5 years. So another 15 years, we ought to be there, huh? All right. 15 more years and I can quit my day job. Fabulous. Fabulous. So if you haven't done so already, like, subscribe, share, tell a friend. Hey, this Reich guy, he's not as bad as, I make him out to be. Heck, we've even had people that said, I didn't like defense attorneys before I started listening to you, Scott, but now I kind of respect what they have to do. We were talking about the Lori Vallow case. We had somebody call in one night and they asked a question. They knew the defense attorney for Lori Vallow, and people weren't being nice to him. Yeah, I've probably been a little rude to defense attorney's family as well. And I said, you know what? You don't have to like what the defense attorney is. You don't have to like their client. And I told him, if you see him, you can tell him, hey, I don't like your client, but I totally respect what you're doing. And I'm telling you, it's those little defense attorneys out there on the line every day, the public defenders, the court-appointed attorneys, the guy taking the case that he feels bad for the defendant, even though he's totally losing money on that case, but he wants to make sure the guy doesn't get screwed by the government, who's not going to be their friend and say, I'm going to make you this offer because it really helps my stats. But if an attorney shows up, suddenly they're like, we're going to dismiss his case. We can't prove it. Yeah, happens all the time. So that's what I tell people. I tell people, I don't care if you hire me or somebody else. Go get yourself an attorney. If you can't afford to hire one, go get the public defender. Anything is better than no attorney at all when you go to court. And most of the time, you're going to keep yourself from talking yourself into a conviction. All right. Let's switch gears here. Let's talk about the former president, Donald Trump. Okay. And this always gets interesting whenever we talk about the legal troubles of the former president. Literally in the same comments on the same subject matter, we will get, "You're pro-Trump. You're anti-Trump. I'm unsubscribing." Don't care. Not getting political. Okay. But let's treat this as anybody. Let's say, for example, you got a letter from a United States attorney saying that you are the target of an investigation. All right. So let's keep it in that context. Keep the Trump name out of it. Let's say you get a letter saying, "Hey, guess what? We've been watching you and we've convened a grand jury and they're investigating you and you are deemed a target, i.e., you're going to be a future defendant in this particular case. But since we're fair, because we're the government and all, we'd like to make you an opportunity you can't refuse. We'd like you to come talk to the grand jury and hear your side of the story." Well, any U.S. attorney or state attorney, in that matter, knows that any attorney worth their salt is going to tell their client, "You're not going in there. If they're going to indict you, it doesn't matter what you say." And frankly, since the defense attorneys don't get to ask questions in there, and the prosecutor would be the one asking you questions, and maybe a grand juror could ask you a question or two, but they can't be advocates or anything along those lines, probably not going to have a whole lot of people on your side in there. So any attorney worth their salt is going to have to tell the United States attorney, "Dear United States attorney, thank you for your kind letter informing my client that they are a target of a grand jury investigation. Unfortunately, my client is going to have to decline your gracious invitation to speak at the grand jury. However, I advise you that without making any admissions whatsoever, I am telling you that if my client were called before the grand jury, since I have no idea exactly what you're asking about, they would assert their rights under the Fifth Amendment based upon advice of counsel, not because they want to, but because, well, it's advice of counsel, and they're going to listen to their counsel. And that's what's going to have to take place." And so what happens when your client so graciously refuses the invitation to come to a dinner? What do they say? If you don't have a place at the table, you're what's served for dinner. I think that's like a grand jury. You don't really have a place at the table. You're what's for dinner. They're coming for you. So guess what? Then you do is you wait. And then you say, "Hey, United States attorney, since you've been so gracious and I have been so gracious as to inform you that we're not going to go through this rigmarole, we're going to waste everybody's time, please let me know if an indictment is returned and we can make arrangements to surrender our client and have him processed and make him arrive at his first appearance as expeditiously as possible so that this matter can be resolved before a jury of the defendant's peers." There you go. Now, do United States attorneys always do that? Do they always say, respond back and say, "Oh, defense attorney, you've been gracious. I've been gracious. We're all so gracious. We're being so gracious. We're all going to get along together. And yes, we'll let you know. We'll get it on the docket. We'll coordinate. Don't worry about it." I thought I was having those kinds of gracious conversations just recently. Little did I know, but that's the stage of who you can trust. I gave my word. Let me know. We will fly to another state. Heck, we're going to get in CrimeTalk 1. We'll fly there, surrender them, make life easy for everybody. But what did that U.S. attorney do on the other side? That said he was being gracious, and I will let you know because I'm gracious, you're gracious. We're going to get along. We're going to resolve. It's going to be great. Oh, no. They didn't do that. They sent the marshals to my client's house at 6 a.m. while he's making breakfast in a T-shirt and his underwear. And then I get a call saying, hey, your client's appearing in the United States District Court this morning. No, that's not possible because I was being gracious and I told the United States attorney and he agreed to let me know. So clearly something is wrong. You must have the wrong client in the courthouse. And they figured out, nope, not the wrong client. Yep, definitely the client. And the client's saying, get me the hell out of here. I thought the United States attorney was going to call and this wasn't going to happen. Well, obviously we know who we can and can't trust in these circumstances right now. Exactly. It's a trust thing. So we have to be gracious. It also comes down to trust. And when somebody starts out like that, like so many things in life, everybody makes big promises. Very few people actually ever deliver the goods. Rigmarole. Is that a college word? I don't know. I think that's a word my parents used to use, kind of like catch as catch can. Still don't know exactly what that is, but I basically knew that was fend for yourself. Hey, what's for dinner tonight? Oh, it's catch as catch can. I don't really know what that was, other than I'm on my own. Okay. So Donald Trump, like I said, you take Donald Trump's name out of it. Don't get into the political aspects of it. Your client's going to get a target letter. They're going to get indicted. You got to deal with reality. So what's the big stuff? They're saying it's going to be about the January 6th. Now, why did people want to make a big deal about this? Well, because if the president is convicted of some sort of sedition, insurrection, rebellion, guess what? Pursuant to the 14th Amendment to the United States Constitution, 14th Amendment, Section 3, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid and comfort to the enemies thereof. But Congress may vote of 2/3 of each house remove such disability. So if he is charged with insurrection, which the legal definition, Insurrection 10 United States Code, Chapter 13, opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. So if you challenge the laws, therefore, then you are committing insurrection? Well, that's a pretty broad brush to sweep, don't you think? Maybe it's a rebellion. Let's look under 18 United States Code, Section 2383. Whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid and comfort thereto, shall be fined under this title or imprisoned not more than 10 years or both, and shall be incapable of holding any office under the United States. So, like I said, whoever incites, right, sets on foot. There's a history term you're going to have to go back and research back to the founders of the Constitution, right? The 14th Amendment. What was set on foot? Assists or engages in any rebellion or insurrection against the authority of the United States. And like I said, we looked at 1323. An act of rebellion or insurrection against the United States government constitutes a serious federal crime punishable by serious offenses. While peaceful protests are legal and are protected by the Constitution, violence and destruction are not. Is that like looting or something? You don't like it, so you go burn the city down? Would that be rebellion? Destruction? I don't know. Anyway, rebellion and insurrection apply when the perpetrators destroy government property or assault federal officers. This type of illegal behavior is considered a crime against the United States and the Constitution. It's important to note that 18 United States Code 2383 insurrection and rebellion charges are rarely filed by the United States Department of Justice because they recognize the First Amendment right to free speech. Still, specific unlawful behavior could result in criminal charges under this statute. Obviously, you can't, yell fire in a crowded theater, I guess, but I don't know. We'll see if that takes place. But the reality of it is, whether you think it's justified or whether you think it's just, political motivation, they're going to get their guy. And if he's convicted, he'll never be able to hold office again, which is truly what they want. Then it doesn't really matter. Right? I mean, but the reality of it is, if you look at it from a legal aspect, you have to be concerned. Anytime your client gets indicted, their liberty is at stake. And like I said, I've had lots of cases over the years where there's been political motivation. Things never would have been charged, but for, people making a big outcry about it. Politicians want to get elected, it's reality. And guess what? You can't really get up there and argue, hey, this is jury nullification because this is all just a political hack job. No, you can't do that. You have to argue the law. So it's always very interesting what to think about. And, the bottom line is, I mean, and Donald Trump is having trouble getting attorneys in South Florida. Plus, he's got the stuff in New York going on, which I think if you look at that with some intellectual honesty, that's kind of a stretch. The feds wouldn't take that case federally under the legal theory that the prosecutors in New York State are prosecuting the Trump or the Trump organization under. And then you got the whole thing down in Florida where, he probably's got a 50-50 shot. There's no guarantee. They don't check political affiliations when you check in for jury service. They just don't care. It's not supposed to matter. And I don't think it does. I think jurors will follow the law. But there's some people, they may vote for jury nullification. I don't know. But if, Trump gets indicted in DC, he's got trouble. He's not a big fan in DC by either the Republicans or the Democrats because a lot of them, they are, as Ayn Rand used to say, looters. And let me find this quote. Because this is what politicians and Ayn Rand is one of my favorite authors. You should read the book. Atlas Shrugged. It'll change your life. When a society establishes criminals by right and looters by law, men who use force to seize the wealth of disarmed victims, then money becomes its creator's avenger. Such looters believe it's safe to rob defenseless men once they've passed a law to disarm them, but their loot becomes the magnet for other looters who get it from them as they got it. Then the race goes, not to the ablest at most production, but to those most ruthless and brutality. When fourth is the standard, the murderer wins over the pickpocketer, and then the society vanishes in a spread of ruins and slaughter. That's not the best one I was looking for. But they're all good. She was really good. Ooh. Let's find the quote here where they talk about you'll know the looters. So true. Why can't I find that? Men who trade in favors. Ayn Rand. Yes, here it is. When you see that trading is done not by consent, but by compulsion, when you see that in order to produce, you need to obtain permission from men who produce nothing, when you see that money is flowing to those who deal not in goods, but in favors, when you see that men get richer by graft and pull than by hard work, hold on, let me just start from the beginning. It's such a great quote. When you see that in order to produce, you need to obtain permission from men who produce nothing. When you see that money is flowing to those who deal not in goods, but in favors, when you see that men get richer by graft and by pull than by work, and your laws don't protect you against them, but protect them against you, when you see corruption being rewarded and honesty becoming self-sacrifice, you may know that your society is doomed. So, yep, there you go. We'll have to wait and see. We'll have to wait and see, ladies and gentlemen. Looks like there's an indictment watch for sure. So we'll just have to check that out. All right. It's been an hour. I want to thank everybody for joining us. If you'd like to continue the conversation, jump over to our Patreon show. You can do that. If you're not a member, sign up down below. Get the link. Boom, you'll be in, and we'll continue the conversation. And we're going to do the call-in because, frankly, we just never got to it tonight because it went by so fast. My fault, Frank. Anyway, thanks for watching. We'll see you next time on Crime Talk.